Wow. Good arm.
The room has good acoustics. Good afternoon. Pursuant to the order of reference of Monday, January the 29th, 2018, the committee is resuming its consideration of Bill C-65, an act to amend the Canada Labour Code, Harassment and Violence, the Parliamentary Employment and Staff Relations Act, and the Budget Implementation Act 2017, number 1. Today, the committee will hear from federally regulated private sector employers. We are very pleased to be joined today via teleconference from the Quebec Employers Council, Yves Thomas Dorval, President and Chief Executive Officer, and Guy-François Lamy, Vice President, Work and Legal Affairs. Can you gentlemen hear me?
Yes, we hear you very well. Thank you.
Excellent. Before I forget, when you are speaking, if just for the recording of the testimony, if you could identify yourself before, because if you go back and forth, we won't know who said what.
Yes.
Okay. And joining us here today from Canada Post Corporation, we have Anne-Theresa McEachern, Vice President, Human Resources, and Manon Fortin, Vice President, Operations Integration. Welcome to both of you. From the Canadian Bankers Association, Marina Mandel, Assistant General Counsel. Welcome. And from the Federally Regulated Employers Transportation and Communications, or FETCO, we have Derek Hines, Executive Director. Welcome, sir. And from Folger Rubinoff, LLP, we have Cheryl Johnson, lawyer. Welcome. Did I say that right? Is it
Foglers?
Fogler? Okay. I was trying to get fancy there. So each of you will have 7 minutes, and in your opening remarks, then we'll have a series of questions. So we're going to start off with the Quebec Employers Council. Gentlemen, the next 7 minutes are yours, and if you can identify yourself, that would be great. Thank you very much.
My name is Yves Thomas Dorval. I'm the CEO of Conseil des Patronats du Québec and Quebec Employers Council. I'd like to thank the committee for hearing us about the Bill C-65. I will speak in French, but you can answer your question in English. So, of course, for people who need it, they will need a translation from French to English. Alors, le Conseil du patronat est une...
So, the Quebec Employers Council is a federation of employers who deal with 70,000 employers. Some of them are under provincial legislation and others under federal legislation. Our mandate is to make sure that employers have the best possible conditions to prosper and to make sure that work environments are exempt from violence and harassment. We fully support a productive environment which is good for the health of all employers. We support objectives, the objectives in the bill, in order to enforce the present system in preventing harassment and violence. Nevertheless, in the opinion of the CPQ, certain elements in the bill could be improved, at least in part. And in our brief, we draw a parallel with the regulations existing in Quebec with respect to harassment and also with a view to the Quebec experience. The Quebec experience has shown that the subjective character and the subjectivity of perceptions has created problems in cases of psychological harassment. And in our brief, there are citations that mention that there is not in this area, not everyone is helped. Not everything can be done the same way. Some things have to be done in a particular manner. Now, our experience shows that psychological harassment has been alleged in certain cases by people suffering from personal problems, which can issue from work conflicts, but they're not always the same for everyone. When we talk about the definition of notions of violence and harassment, these are not defined in the bill, but Section 14 says that these could be defined in regulations. And this raises to our mind certain questions. We ask why the definition of such an important issue would not be in the code directly. It is a concept that is extremely complex, and therefore we think it deserves to be defined very carefully. Given the issues, we cite the example of Quebec, where psychological harassment is defined as follows. This is a vexatious conduct manifesting in behavior, words, actions that are repeated and which are hostile or non-desired, which affect the dignity or the health or psychological health of someone and creates adverse conditions in the workplace. A single act can constitute harassment under this definition. Now, experience shows that even if psychological harassment is defined, it seems that at first blush that it's something that could be better fleshed out. In our brief, we mention questions of the right to manage on the part of the employer, and that there are sometimes work conflicts. It's also important to rigorously define what constitutes psychological harassment or violence. Under the Labor Code, it is mentioned, and also in our brief, we mentioned that notions of harassment and violence can also cover acts of a sexual nature, which are also covered in regulations. If the bill were passed by the House in its present state, it's necessary that they would have to adopt regulations simultaneously, otherwise there would be a legal void. Now, if it's necessary during the process, we say in the brief that certain changes may be timely, and if the department, in dealing with the resolution of complaints, that in the resolution of complaints this might lead to certain issues. We're looking at best practices on the international scene, and these show that the environment must deal with this issue. There can be interventions when necessary, but we would remind you that we have to deal with this in a very careful way. And finally, in conclusion, we say about the bill that we would bring certain gradations of meaning, certain gradations of difference, certain nuances to this bill. And I think we might be able also to bring certain clarifications to bear. Thank you.
Up next, excuse me, from the Canada Post Corporation, Anna Teresa McEachern and Manon Fortin. The next 7 minutes are yours.
Thank you. Thank you to the Chair and committee members for inviting us to participate in this important discussion on Bill C-65. I'm Anne-Therese McEachern. I'm Vice President of Human Resources. I'm with my colleague Manon Fortin, who's Vice President of Operations Integration. We're proud to represent Canada Post, where we both have more than 25 years of experience at various levels within the organization. Harassment and workforce and violence in the workplace is an incredibly important issue, and we hope to contribute in a positive way to the development of this legislation. In the next few minutes, I'll outline our approach to help ensure our people feel safe, respected, and able to do their jobs without threat of harassment or violence. First, it's important to understand the size and scope of our operations. More than 50,000 people, full and part-time, work for Canada Post, not including our subsidiaries. With our size, our employees represent a microcosm of Canadian society. They interact with their colleagues, their supervisors, and countless customers in every province and territory. It's our job to serve Canadians, and we're proud to do so. But it's also important to note that 2/3 of the complaints registered come from employees who believe they've been harassed or worse by a customer. As you see, our approach must be comprehensive, clear, and collaborative. At Canada Post, our commitment to create a workplace that brings out the best in our people and fosters a safe, supportive, and productive environment. Harassment, violence, or bullying in any form is not tolerated between our employees or against our employees. While nobody's perfect, we walk the walk with an approach that's focused on 3 main pillars. First is prevention, through leadership, standards, training, and policies that reinforce expectations. Collaboration with our unions is also key. Second is an effective, appropriate, and timely response if an issue occurs, with numerous avenues for employees to be heard. Third is to review results, seek input, and look for areas to evolve and continuously improve our approach. Prevention is the most important, so let me start there. It first starts with the tone that's set by the corporation through our values, our code of conduct, and our policies. As well, all 5 of our collective agreements include provisions with human rights clauses. These are more than just paper. They shape the culture and define the standards to which all employees must hold themselves accountable. Leadership is where this approach is most evident. The day-to-day interactions our team leaders have with their employees, the tone they set, are incredibly important. It's where I've seen a great deal of positive change in the last few years. Leaders who are accessible, know their people, engage with them in the workplace, and recognize good performance see better results. It also helps them to address issues with coaching, communication, and common sense. To assist them, we provide training when they're first hired and refresher sessions on a regular basis. Core to the training is how to create a workplace free of discrimination and harassment. We also provide this type of training to all employees, starting with our onboarding process. I can provide more detail on the training during our discussion, but I'd like to highlight one example that demonstrates the importance we put on collaboration. For more than 10 years, employees who are members of the Canadian Union of Postal Workers participate in a training program called Human Rights and Conflict in the Workplace. This half-day training session was jointly developed and is co-facilitated with CUPW, our largest union. Approximately 30,000 employees have completed the training. Topics such as diversity in the workplace, harassment related to human rights, discrimination, and resolving conflicts are well received by participants. This collaboration is not limited to training programs. Within our major facilities, we have long-standing local joint health and safety committees where local management and union representatives work to prevent health and safety risks and address issues in a timely manner. In the event an incident occurs, employees have access to several options where they can be heard and supported based on their comfort level. These are communicated to employees through various means to ensure they're aware of their options as well as the consequences of inappropriate behavior. In all, employees have access to no less than 8 different avenues, ranging from a discussion with a supervisor to confidential or anonymous programs run by third parties on behalf of Canada Post. I'd be happy to outline these in greater details when we move to questions. Regardless of their choice, complaints are addressed in a prompt and respectful manner. When investigating, management will not disclose the complainant's identity unless doing so is essential to resolving the complaint. This is important to the integrity of the process. Just as important is ensuring the employee has the proper support in place once a report is filed. The investigation is quickly initiated and logged to ensure a proper response. The employee also has various avenues to turn to, like employee assistance, for additional support. Following an investigation, and depending on the circumstances, a range of consequences can apply. Some incidents are resolved with a frank conversation or a warning, while others involve more in-depth intervention. For serious violations, nothing short of dismissing the employee is the right thing to do. These decisions are never taken lightly. As I said at the beginning, we've made progress, but improving workplace health, safety, and well-being is a continuous evolution. We collect and examine data on all our programs and review it regularly for trends, root cause analysis, and improvement opportunities. This isn't just number crunching. It's important in our ongoing improvement. Data allows us to detect trends to determine systemic issues. For example, this detailed level of analysis has greatly helped to determine where we should place additional resources and support. On behalf of Canada Post, I'd like to thank the committee for inviting us to appear. We applaud the government and members of the committee for working to provide clear expectations and direction for all federal employers through Bill C-65. Harassment, intimidation, and violence should not be tolerated in the workplace or any place. Employees should feel they have proper training, support, and protection, regardless of where they work. Our approach has evolved over many years and aligns with the desired future state described in Bill C-65. We will continue to evolve and improve our approach to not only comply with the final legislation, but also seek further improvements. This is an important conversation, and you're on the right track. Start with prevention and collaboration, as it will have a tremendous positive impact on workplace culture. Ensure there are numerous avenues for employees to be heard and respected, and constantly monitor progress and look for opportunities to improve. We'd be happy to take your questions. Thank you.
Thank you very much. And now from the Canadian Bankers Association, Marina Mandal, Assistant General Counsel. 7 minutes, please.
Thank you for inviting the Canadian Bankers Association to appear this afternoon to participate in the committee's review of Bill C-65. My name is Marina Mandal, and I'm the CBA's Assistant General Counsel. The CBA is the voice of more than 60 domestic and foreign banks that drive Canada's economic growth and prosperity. The CBA advocates for public policies that contribute to a sound, thriving banking system to ensure Canadians can succeed in their financial goals. Canada's banks fully support the federal government's actions to strengthen legislation on harassment and violence in the workplace. The CBA's position on this issue is clear. Harassment and violence have no place in the workforce or in society. Canada's banking sector will continue to set an example for creating safe, rewarding, and respectful work environments for all employees. The CBA actively participated in the government's consultations leading to Bill C-65, and we are pleased that the bill contains provisions that address what was a key focus for us, protecting the privacy and confidentiality of employees throughout the process of investigating any allegation of harassment or violence. We look forward to working with the government to ensure that Canada continues to have world-class health and safety advancements for all Canadians, including the more than 275,000 diverse employees of Canada's banking sector. Canadian banks pride themselves on having leading practices in place to help prevent and address harassment in the workplace. In fact, many of the measures outlined in Bill C-65 are already reflected in existing bank practices. Banks have clear written policies that outline the following: behaviors considered to be workplace violence or harassment, steps employees should take when aware of an incident, how the organization will respond to allegations, and explicit protection against retaliation for raising a concern about workplace violence or harassment. Banks also have mandatory training for all employees on violence and harassment as a condition of continued employment. If a complaint is brought forward in a bank, there are multiple channels through which incidents of violence or harassment may be reported. This includes channels that do not involve the party's direct management, such as an ombudsman office, which is independent of other bank departments and reports directly to the most senior levels of the bank, directly to the general counsel or the bank's president and CEO. Banks investigate all allegations of workplace violence or harassment and, more generally, inappropriate conduct, regardless of whether the alleged conduct, if it was found to have occurred, would meet the definition of workplace violence or harassment under either the bank's own code of conduct or employee policy or under the law. Prior to commencing an investigation, banks will determine whether it is appropriate for the parties to remain in the workplace during the course of the investigation, and will ensure all parties are offered personal support during the investigation, for example, through counseling services offered through the bank's Employee Assistance Program. Once the investigation is complete, they will communicate the findings of the investigation to all complainants and respondents prior to notifying them of the outcome or implementing corrective action. Internal bank review processes must align with legislation and common law, but are created to be flexible in order to account for practical realities. Banks also ensure that all investigations are conducted by a trained investigator who is impartial to the parties involved. In her speech in the House of Commons, Minister Haydu said, quote, "The government recognizes that safe workplaces, free of harassment and violence, are critical to the well-being of Canadian workers," end quote. We agree with the Minister's statement, and banks have long worked hard to ensure this is the case within their institutions. Thank you once again for inviting the Canadian Bankers Association to participate in the committee's review of Bill C-65. I welcome any questions you may have.
Thank you, Ms. Mendel. Next, we have from Federally Regulated Employers, Transportation and Communications, FETCO, Derek Hines, Executive Director. So
Thank you, Chair.
A little bit of feedback. I'm wondering if you can turn down your...
I'll just take it off.
Okay, thank you.
Thank you, Chair. Thank you, Committee, for having me here today. Pleased to be here to speak to you on behalf of FETCO about Bill C-65. By way of background, I should tell you that FETCO stands for Federally Regulated Employers, Transportation and Communications. That's a mouthful, so we usually go by the acronym FETCO. Our members are all federally regulated firms in the transportation and communications sectors. We've existed as an employers association for over 30 years. We are generally large employers in the federal sector, encompassing nearly 500,000 employees and representing well-known firms such as Air Canada, Bell, CN, CP Railway, and TELUS, to name a few. Our members are almost exclusively predominantly unionized firms, and we have a rich history of tripartite collaboration within the federal sector. Our key message today is this: FETCO members are highly supportive of the spirit and intent of Bill C-65. We support the Minister's commitment to ensure employees have access to an efficient and effective process when they bring forward complaints of violence and/or harassment in the workplace. Canadian workplaces should be free from harassment and violence, period. To this end, our member organizations typically have in place workplace policies that are already largely consistent with the process that will henceforth be mandated under Part 2 of the Canada Labour Code via this bill. We are committed to doing all that we can as employers to improve these processes where deficiencies might exist. FETCO members applaud the Minister and senior officials from ESDC on the work completed to date on this matter, especially related to the comprehensive consultation that has been undertaken over the past 18 months, which we expect will continue once the bill becomes law. This bill, I believe, in fact, comes from that consultation. The consultation work dates back to June of 2016. In tripartite meetings held on harassment in the workplace, FETCO members note that government has heard and subsequently responded to concerns raised by key stakeholders. Bill C-65 acknowledges these concerns related to the protection of privacy in the process, the role of the workplace committees, and the responsibilities of the ESDC health and safety officers. FETCO members also appreciate that government has chosen to provide a broad framework via this piece of legislation, but allow some of the details to be worked out by the parties via the regulatory process. As an example, we are pleased to see that the definition of harassment will be tackled via regulation, thereby allowing two things. First, that the definition can be revised on an ongoing basis in a more seamless manner via a regulatory review undertaking. Second, that key stakeholders of note, representatives from both the labour and business communities, can be involved in developing these important definitions. FETCO's review of Bill C-65 has resulted in two specific concerns that we hope your committee can consider in your ongoing review of the bill. In fact, I think it's fair to say that our concerns are probably more on the operationalization of the bill through the regulatory process, but I'd like to raise them at this table nonetheless. First, we would appreciate if the government provided greater clarity on the potential intersection of this new ESDC harassment process under Bill C-65 with the investigatory powers of the Canadian Human Rights Commission. Our hope is that there would be a single, clearly defined process for all harassment complaints. Bill C-65 and the Canadian Human Rights Act provide dual opportunities for such complaints. Each, however, has specific language that could refuse complaints that are being heard elsewhere, but it would add certainty if government provided clear direction that these clauses would be used when dual complaints on essentially the same issue are filed. Second, Bill C-65 speaks to the appointment of a competent person to investigate all harassment and/or violence complaints. We request that government provide greater clarity on this process, as there is already some confusion in this space under the current violence investigation process. Specifically, we request that government acknowledge competent persons can be employees in the organization in question, and that the employer retain the ultimate responsibility for appointing the competent person as long as they meet the clear criteria that are outlined under regulation. The process should not necessarily default to an outside investigator. In conclusion, I would like to repeat our key message. Canadian workplaces should be free from harassment and violence, period. FETCO members are highly supportive of the spirit and intent of Bill C-65. Our members' current practices generally align with this bill. We support the Minister's commitment to ensure employees have access to an efficient and effective process when they bring forward complaints of violence and/or harassment in the workplace. We are pleased to be part of this solution. Thank you.
Thank you, Mr. Hines. Next, we have from Fogler Rubinoff, LLP, Cheryl Johnson, lawyer. Next 7 minutes are all yours.
Thank you. I think primarily the reason why I'm here is I do think my textbook has come to the attention of someone with regards to, it was published in September, and it's a guide for understanding and prevention of sexual harassment. And it's not just focused on the workplace, but I have been practicing labor and employment law for over 20 years now. So I've had a lot of experience on both sides of the road, and with regards to the practical implementation of what you're suggesting with regards to the bill. And what I thought I could comment on would be with regards to what my friends have said. And I do agree that what needs to be included in the bill is recognition that it should be dealt by the parties internally. However, there should be mechanisms built in as well that if the parties don't get it right, and if the employer doesn't do a proper investigation, that it does go default back to the government in order to address it, just to make sure there's a safety valve there with regards to getting it right in the workplace, because it never should be the case that anyone has to endure that as part of the terms and conditions of their employment. With regards to the definition of harassment, generally it is included right in the legislation, and currently there is the definition of sexual harassment in the code. It's there specifically. I do believe that that definition should be updated. A lot of people, and especially when I'm doing training with regards to sexual harassment, and even when I was doing the cover for my book, they were coming back to me with pictures that involved touching, and it was a man touching a woman. Sexual harassment can happen to anybody in the workplace. It can happen regardless of your sex or your gender identity, your gender expression, your sexual orientation. And the way that sexual harassment is currently defined, it still seems like it's the case when it involves a man and a woman and there's touching, or it's something of a sexual nature. And as discussed earlier, there's psychological harassment. There's all forms of harassment that can happen in the workplace, and it's not just limited when we're talking about sexual harassment to actual sexual advances, sexual solicitation, unwanted touching, unwanted comments. And I do think that the code needs to be updated in that regard. And I agree with my friends and the practicality with regards to balancing this important issue and preventing anyone having to endure as a term and condition of employment harassment or violence with the need for privacy. Lately, we haven't had that, and lately it's been the case that people have been assumed guilty without due process. And unfortunately, that ruins people's reputations and their careers. And so I applaud the efforts made in this bill to ensure that privacy is respected with regards to the process. And again, part of my process with writing the book and part of my practical experience and hearing what my friends have said, especially Canada Post with regards to their process, is that you need to have the prevention and collaboration and the effective and timely responses and the review and updating. Now, I did look at the bill with regards to sections 3.1 and 3.3 about sections 125.1 and the regulations. And I would encourage to be considered that in that you address specifically not just general policies, but policies for anti-harassment and anti-discrimination and anti-violence to be specific requirements, because I don't see that specific wording currently in the bill as it's drafted, and I do believe that would be a way of giving some teeth and ensuring that this is implemented and that this process is followed through in the way that you intend it to be. And one other pitfall or potential pitfall that you might experience with the way that it's currently drafted is it talks about the amendments in subsection 5.1 for section 127.1 of the Act for it to be reported to a supervisor. It can well be the case that the supervisor is the one who is the alleged harasser. And so that person can't be the one that you go to or be the one that you address the complaints to. And with regards to what the banks do, and they have an independent outside party, the ombudsman, accepting those, because it's going to be the case that it might be the supervisor or the supervisor's manager. And so the supervisor isn't in a position to be the one in order to address the issues or concerns. So having an outside individual that's not directly in the line of that person's chain of command is something that should be addressed and included in the legislation. And I'm happy to answer any other questions, concerns you have with regards to practicalities of implementation or anything with regards to sexual harassment generally.
Excellent. Thank you very much, Mrs.
You're
Johnson. First up, we have MP Kmitch, 6 minutes.
Thank you, Mr. Chair. Donc, je vais commencer avec le Conseil du patronat du Québec.
I'm going to start with the Quebec Employers Council. I have a few questions. You said that in your submission you had some examples of ways to improve the bill, but you talked about employers' management rights. What the committee heard yesterday in other testimony is that there is a difference of opinion. And I'm not thinking of sexual harassment, but harassment in the workplace. So the difference between harassment, which might affect performance, and what an employer should do in the workplace in order that the worker does the work he or she is receiving a salary for. So there's a very fine line between harassment and managing staff. So where does the council draw this line between the two? Is there do they have to go to a source of information outside, or are there any examples that you have in your council that you could give members? Thank you. It's Guy François Lamy speaking. I'll say that there is a definition of psychological harassment we find in the Quebec legislation to the effect that it is conduct, vexatious conduct, or hostile, generally repetitive in nature, which leads to a state of psychological harassment. In Quebec, there has been a significant volume of complaints which you could refer to with respect to managers' rights. And you might perhaps not understand or just not be aware of the full definition of psychological harassment. For example, a manager who follows up on the performance of a salaried worker, well, this does not necessarily constitute psychological harassment. If the follow-up is part of managing an employee, can this be considered vexatious or hostile? Where is the line to be drawn? And this is why we find it interesting and we find it important to distinguish what constitutes a psychological harassment, taking into account management rights, and when there should be interventions to see whether or not this exists. Otherwise, it'll always be psychological harassment, whereas there are comments that a person might not like, but they might not be vexatious. But it's where someone feels the comments are being made in a malicious way. Well, here's another question. Would you agree that the federal legislation should be closer to the Quebec legislation? I have here a definition of psychological harassment. It's quite a long definition, but they also give criteria: vexatious, hostile, repeated, non-desired, harming someone's dignity, making the workplace, producing adverse effects in the workplace. Do you think that a full definition with criteria would help us determine whether or not there were a case of harassment? Should this be in the federal legislation? Well, I think the definition in the Quebec legislation is a good one. What I would add to improve the Quebec legislation, I would suggest that one add a definition of what does not constitute psychological harassment. And you also have the federal model of what does not constitute discrimination. So I think we might have something that talks about what does not constitute psychological harassment and might be more properly seen under management rights.
Mr. Hines, you said that your preference was not to have a definition in the law on what constitutes harassment. Can you please explain some more on why you say that? Because to my mind, and I'm not a lawyer, I'll say that right away, but my understanding is it would be preferable to have a fixed definition either in the law or a very fixed definition in common law that would make it easier for an employer and employee to understand where is that fine line, where are the risks, to eliminate all the gray zones. So if you have a definition that could change possibly from year to year, something that could be considered harassment in 1 year would not be considered harassment the next year. How would your members feel about being placed in such a situation?
The argument that we've been making is we believe the definition is more suitably placed in the regulations because it allows it to be updated as our understanding of this particular issue changes and evolves over time. And the minister alluded to this in her comments when she talked about cyberbullying. That was something we didn't even know existed a decade ago. Regulations don't change on a dime. They have to go through a process. Regulations are as strong in terms of how they have to be enforced by those over whom they are held, are just as strong as if the language was written directly in the law. We believe that the experts should be engaged fully in developing that definition, constituting what is and what is not harassment. We believe that process will take some time, as it did when we went through Part 20 and did the violence piece of occupational health and safety regulations. You know, it's a process that the parties should go through. The experts from labor, the experts from business, the experts from government, outside stakeholders, so that we can engage fully and comprehensively to get a full understanding of what should and should not be contained in that definition. You know, whether it's at the end of the day in the legislation or in the regulation, I actually don't think it makes a difference in terms of how it will be enforced. but I think having it in the regulation gives us the opportunity, under this broad framework that the government will be creating with Bill C-65 and the changes to the Canada Labour Code, to go through that process, which will take some time, and I frankly don't think could be solved at this table in the weeks ahead around finishing this piece of legislation in particular.
Thank you, sir. MP de Bruzen, please, for 6 minutes.
Thank you. My first question is for Canada Post, and it's just, I don't know if you were both here earlier today, but we actually had Monsieur Giroir from the union who was here earlier today, and he spent his entire opening statement setting out what he saw as, what he described from his perspective as a systemic issues of harassment within his workplace. And I hear that you kind of set out all of the processes that you have in place for people to come forward, but it kind of goes to the heart for me of what we're trying to do here. Because you spoke a lot about collaboration, but clearly this morning there was a fair bit of complaint. So how does this legislation help us to bridge that gap from what I heard this morning to what I'm hearing this afternoon? Like, how can this legislation help, and is there anything that you think that needs to be improved so that we can actually bridge that gap?
So Canada Post has been focused on ensuring we create the right workplace climate for many years. We do have a very collaborative relationship with our unions. Particularly, we share a goal in this particular space, both in health and safety and in workplace harassment. We share a goal to make sure that our people are safe and that are free of harassment. And the way we manage that is through joint committees with our unions. So we have both local and national joint health and safety committees in facilities across the country. And we also have joint human rights and employment equity committees with our unions. So we meet with them at a minimum of twice a year.
It's just, I just because I don't have that much time, but I guess what I'm getting at is that I was presented with two very different perspectives on the same workplace. And I actually believe that you, and then when you say that you both want to have a workplace free of harassment, that's fair. But what I'm trying, because I'm looking at this legislation, and I'm trying to figure out how it's going to address exactly that scenario. So how is it that this legislation responds or can help you better respond to what I heard this morning? And what is there, if you see any gaps where you feel like it might not be responding, that you see, oh, wait a second, that's not going to get us to where we need to get?
I'm not sure the legislation will change things for Canada Post in the sense that we already have many of the goals of the legislation are already in place. So we already have policies on no discrimination, no harassment. We train our people. We have many avenues for them to seek support and redress, and we have consequences. So those things are in place. Maybe where the legislation would be helpful is actually just in the fact that it's coming up, and it'll be another conversation for us to repeat the same things that we do today. In other words, are there things that we can do differently? Are there things that our union would like to see us do differently in the joint committees that we have? That would be perhaps an opportunity for us.
If I may drag the lawyer into this scenario.
She's dying.
Maybe you can help me with this one.
I think one of the things that might be good, and what actually is done in Ontario, is with regards to having it either in your regulations or in the legislation a requirement that there be consultation with the Health and Safety Committee or whatever committee is involved with regards to the drafting of the anti-violence and anti-harassment policy as well as its implementation, because you have a program. Because if you just have a policy and it's sitting on a shelf, that isn't helpful. You need to have education, you need to have reinforcement of it, and you need to go back at least annually and assess, okay, is this working? Why isn't this working? And okay, we've had this issue and concern, so therefore we need to address it sooner than annually, and how can we do that? And having the consultation that's discussed as part of that, I think would be very helpful.
All right. And because you have experience with the Ontario system, are there lessons that we can learn from that legislation things that we should be bringing in? You just mentioned one.
Oh, yeah, no, there's many, when I was hearing the questions earlier with regards to the concern about there being, what it would be an exemption, that any kind of reasonable workplace discipline that occurs, you have an exemption, and it's something built right into the legislation saying, okay, it's the case that any proper management actions with regards to disciplining an employee is not going to be considered harassment under the legislation. We have that in Ontario, and it's just a simple exemption. It's not very long, and it covers that kind of scenario. We do have the definitions in the legislation itself with regards to what constitutes harassment.
Stop you on that one then. Do you like the definitions in the Ontario legislation for harassment, or is there something that you would do to amend that wording if we were going to adopt wording?
I think it's appropriate, and I do actually, the way that the Quebec legislation is drafted, I have looked at it because I went and I reviewed all of Canada's legislation with regards to the issue. Their definition of psychological harassment probably is the best definition. But with regards to defining what harassment is and sexual harassment is, the Ontario version is very good, and it's meant to be flexible enough because not every situation fits every definition, but it's broad enough, and that, the way that the regulation and the wording for the regulation in this bill is worded is with regards to expressions of harassment and violence. And so what that could be is you have a general definition in the legislation, and then you give more clarification in the regulations, and that can be updated in an easier manner. But you have exactly what the one question was. You have the basis, so everybody knows what the rules of the game is. And then as society and our cultural value changes, and as the law changes, because it is fluid, that you have that dealt with in the regulations. And I think that's a fair compromise between the two viewpoints.
Excellent. Thank you. MP Trudel, please.
Merci à tous pour vos.
Thank you all for what you've had to say. Following what Ms. de Brussen said, I have a question for you, Ms. Fortin and Ms. McEachern. Recently, psychological harassment has been denounced in the press, and lately there was a worker, someone who worked with the Prime Minister. The Prime Minister heard about this during his public consultations, an employee who heard about sexual harassment. There have also been witnesses who've talked about how supervisors were responsible for psychological harassment, and this was related to their bonuses. So my first question, is it a culture at Canada Post for people to be compensated in that way? They were talking about sick leave, people doing additional work, doing overtime. My question is, Bill C-65, even though you say you already have measures in place, do you think that this bill could help to improve things and help to mitigate these current practices that have been talked about recently at Canada Post? So, on the issue of compensation for supervisors, no, they're not compensated. There is no incentive with respect to overtime, getting people to work overtime. Our supervisors are responsible for operating a branch of Canada Post and making sure it works in a safe way, in a productive way, and in a way that provides good service to our clients and our customers. There are procedures for various of their duties, and what we ask of them is that they follow these procedures, and generally speaking, this delivers the results that we ask them to deliver. So there are no special incentives for our supervisors. And I am aware of things that have been said in the media and in public. Now, I was with operations for a long time, and I worked in Quebec. I worked in the Atlantic provinces, in the prairies, and I've met with a lot of work groups, and I'll say it, we're not perfect. Excuse me, but we don't have much time. In the bill, in its definition and it falling under health and safety, do you think that that would help deal with complaints? Well, I agree that unions and health and security or health and safety has union members on its board. And I agree that unions and employers have to work together in order to resolve workplace issues, be it harassment, any complaints, anything to improve the work environment. Now, with respect to improving the workplace, we do have the Health and Safety Committee. There are the practices we have in the workplace. With respect to individual cases, I'm not sure, because there is the confidentiality issue, and it is important. There's also an aspect of things that has to remain private and confidential. Well, what if there's a complaint lodged against a supervisor? If there's a problem with a supervisor, do employees have the right to go to this health and safety board? Well, yes, they can go through their union. They can go to human resources. There are various avenues open to them. They can also go to a whistleblower. We publish the numbers over Christmas. And generally, what I've seen in the years I've spent with Canada Post, we have managed, through these various avenues, we've managed to resolve these issues.
Have so many avenues as we recognize that you may need different avenues depending on the situation. But I guess I want to assure the committee that every one of those avenues, every one of the issues that comes forward is looked at. We have zero tolerance for harassment in the workplace. We share that value, we share that goal, and we honor it.
20 seconds.
Je vais laisser la parole à Madame Johnson. Voulez-vous rajouter quelque chose?
Madam Johnson, do you have anything to add with your experience?
Very briefly. One of the things that was mentioned is with regards to ensuring that they can go to somebody. And, you know, it's not always the human resource department. It's not always. I think what the bank is doing with regards to the ombudsman makes employees feel more comfortable coming forward, because it's retribution that is one of the main reasons why employees are afraid to come forward or are afraid to follow through on their complaints and are experiencing what they are in the workplace. Because it is the case, maybe it's not with this employer, but many employers, it's about efficiency. And so nowadays, with the economy the way that it is, I see a lot of people going off on disability leave and having burnout, because it is about bonuses at the end of the day, and the incentive is everybody needs to do more for less, and so that does have an impact. It's not meant to have the impact that it does, but it does, and they're right in that regard.
Thank you. MP Fortier, please.
Merci beaucoup. Je veux vous remercier d'être ici.
Thank you very much, and thank you for being here today. We're all here because we want to find a way to strengthen the bill, Bill C-65. Now, there have been several questions put to you since the beginning, and we see that there is room to improve things. But we want to help change the culture and the status quo. As one colleague said, the status quo is not an option. So how to change the culture, how to protect victims and the people who support them, and how do we strengthen Bill C-65. I'd like to hear what you have to say about the bill. Do we have what we need in the bill, or where do we need to add things or strengthen things in terms of protecting complainants and also their witnesses? Ms. Mondal, please, and a short answer, please.
As Mr. Hines mentioned earlier, we do see this as framework legislation. Our main concerns as the Canadian Bankers Association with the bill in its initial proposal form were addressed, and that was, again, the privacy and the confidentiality of all parties involved in the investigation, as well as the role of the Workplace Health and Safety Committee. That was addressed. So from this point forward, we want to continue the productive dialogue we had with the government to create regulations that fill out the details of the process and provide for clarity and for flexibility, again, for all the parties involved.
Ou Madame Fortin?
What I would say is a little bit of what you heard from our colleague in FEDCO. If there's a dual track happening in terms of an issue coming up either through the Health and Safety Committee or the Human Rights Act, what's important, I think, is clarifying how that will be managed. I know at Canada Post, we actually created a situational analysis for our team leaders so they understand if a complaint comes up and it's a physical, it relates to physical violence versus psychological violence versus a human rights complaint versus general harassment. We've actually created a template to help team leaders understand which avenue do they go to if it falls. And I think to clarify or provide some clarity under the bill would be really helpful.
Mr. Hines, I know you've shared some, but would you add anything else?
Yeah, what I would say about the bill is this bill is coming at the tail end of what we view to be a very positive consultation, and it's in the context of a broader, very positive and societal conversation around the issues of harassment and sexual harassment. That's all good. We've taken what was a one-line obligation under Part 3 of the Canada Labour Code to ensure an employer has a policy in place and expanded it, put it into Part 2, developed a process which employers will now have to follow. As I stated earlier, many of the employers that I represent are already aligning with the steps that the Minister has laid out here. But what has been developed in sliding it into Part 2 was now we've broadened the organizations that are affected and will be responsible to apply this law within their workplaces. We view that all to be extremely positive, and we're happy to be part of that solution.
Madam Johnson, here's some time for you if you want to add some ways to reinforce this.
Yeah, with regards to what could be included in the legislation to help protect witnesses as well as complainants, as well as respondents, right? It's everybody as part of the process. That I would recommend that either in the actual bill itself or in regulations, there be bare minimum standards that are included in companies' policies or programs. So when they have their written policy, and I would see it being an obligation too that it have to be posted in the workplace so employees know about it or available electronically or however it's available so people know they have an avenue, but have it in there as well that all of them have to include there will be no reprisal for anybody who participates in the process or makes a complaint if it's made in good faith. I think that caveat needs to be in there that anything done in good faith, there won't be any reprisals for it, whether you're a witness or whether you're a complainant. I think also it should state in there that everything will be as confidential as possible, right? Because, I do investigations myself, and sometimes you have to give out who the complainant's name is in the circumstances because you have to do the investigation, right? And so I think have it in there that there's a statement that it will be as confidential as possible. And then one last, with regards to all the different horses that you can ride federally, in Ontario, it's only been between like human rights and civilly that there's a limitation. You can do one or the other, and you might want to consider that with regards to it doesn't really fit. It depends on how you want it addressed, because the definition of workplace violence and harassment under Part 2 is far broader than human rights. It's not limited to the human rights. And so I would see there is some overlap because it can be based on enumerated ground, but having it be that you can only do occupational health and safety versus human rights doesn't really fit in the circumstances, but have it being generally having it be if you're if you're going to choose to do it this way,
Quickly, I'd
then
like
you can't
to
do the
ask
other.
also. Okay,
Yeah.
thank you very much. Pardon? Yeah, Monsieur Dorval, rapidement, ou Monsieur Lamy, est-ce que...
Mr. Dorval or Mr. Lamy, do you have any suggestions you'd like to put forward? Yes, I would perhaps add that the determining element with respect to psychological harassment is that information has to be available to employees. And also it's by talking about it that we'll be able to change cultures. It was mentioned that confidentiality, that was something that had to be respected, but we have to look at the limits of confidentiality. Sometimes it's necessary in order to be effective in an investigation.
All of you. It seems to me in listening to the testimony that we heard this morning and the testimony this afternoon, there is a gap in terms of the policy versus implementation. And I know, Ms. Johnson, you are an expert in terms of implementation. I know that the purpose behind C65 is that it isn't just about having a policy and implementing the policy. We need to make sure that there are processes in place, that there is recourse if the processes are not followed. So, Ms. Johnson, could you talk a little bit about how do you sometimes this is part of the systemic issues or the workplace culture. How do you bridge that gap between having the perfect policy and people who probably believe the policy is being implemented, and then the lived experience of the employees on the ground that would tell you otherwise?
I think it's the idea of collaboration again, as well as the idea of being open-minded as an employer. That you want to believe that you're doing everything, but I always believe and encourage employers to do workplace audits, to go in, see your culture of your organization, see what it's doing, see how the employees treat each other, see how the employees treat the employer's belongings and property. That gives you a pretty good example if they think you're actually doing what you say you're doing as an employer. Because if you don't respect your employer, you're not going to respect your employer's property. If your employer is telling you that everyone's to be treated with dignity and people aren't, look at the fact that you have high absenteeism, high turnover, all these different things. I think as organizations, with regards to the implementation, they have to be realistic and open-minded beyond just just having the best policy. And education is one of the most important parts with regards to implementation and what was said by my friend with regards to leadership. The leadership needs to own it and, not just talk the talk, but walk the walk.
How do we get more people to step forward? Because we heard yesterday 22% of people in public service say they've experienced harassment, and yet very few of them actually take action. So I know one of the solutions that was proposed was having an arm's length body, like a tip line or something like that. I'd like to know more about the ombudsperson office that Ms. Mandel mentioned, and then if I could go to the rest of you on how do you get more people to step forward?
Sure. So I think it's, as Ms. Johnson alluded to, it's a really great way to ensure that there is, the chilling effect that other stakeholders have talked about, the concerns that employees have from a privacy perspective as well as a fear of reprisal perspective, the concerns they have about coming forward. A lot of that, if not all of it, is taken away with the anonymous tip line. Information is disclosed about the person who's being accused, not necessarily, but it is disclosed. But the complainant can stay anonymous and the investigation can proceed in the background. In most cases, the Employee Ombudsman's Office reports directly into the President and CEO. So again, being that independence from the lines of business, including the person's own business, is extremely helpful. And there's other ways in which, obviously, privacy, confidentiality, fear of reprisal is managed at the banks, but for that particular function you're talking about, that's the general outline.
Okay, and the others, Ms. McKechnie?
Sorry. So I think the creating those independent avenues for employees to report what they're living through is really important. So the Ombudsman is one. We have that as well. The whistleblowing line is another. And ultimately, it's the action that follows. So the witnesses are watching. And having been involved in a few of these through some of the independent lines. I think that's probably the most important. So the leadership piece, building those things into performance management plans and really taking care to put the right words there and to evaluate leaders appropriately according to that is, to me, very critical in all of this. Not sure you put that in the law, but that's what I think could work.
Yeah, consistent with that, when I asked our member organizations about this, many are proud of the way they're handling this. It starts at the top. There is leadership involved. Offices that are handling complaints report directly into the CEO. There's a culture around the importance of bringing forward complaints, a clearly defined process in place, a policy that is well communicated, training that's delivered to those who have to do the investigation. So it's really the growing awareness building around the issue. To Ms. Mandel's point about the Ombudsman, I've heard some of our members have that. Some have, anonymous tip lines. The number of avenues you can provide a complainant to bring forward a complaint certainly seems to enhance the number of reports as well.
And one of the deterrents for many people in putting forth a complaint is if you see other people who've done it before and there hasn't been action or discipline or anything take place. And that's a bit of a dilemma because, of course, the privacy needs may actually prevent people from being able to say when some of those actions have taken place. How do you overcome that? And is there anything in C65 right now that would help with that, or could there be? Yeah, Ms. Johnson?
There could be. What's done in Ontario is that when it's a worker and when they're the complainant and an investigation is done, then both the complainant as well as the respondent get advised what the results of what the investigation is and any implementation that's done with regards to progressive discipline or any action that's done by the employer. So they have to be informed. And I actually know of employers who've done the investigation, did all that properly, but didn't follow through with regards to advising the parties, and they actually got an order from the minister to advise.
Thank you.
So there is some teeth with regards to that.
Thank you very much. And now for 6 minutes, MP Ginas, please.
Thank you, Mr. Chair. I think it was Mr. Dorval who talked about vexatiousness as a key element of psychological harassment. Is this a subjective concept? And I guess vexatiousness in the eyes of who? In the eyes of the harasser, harassee, a dispassionate observer? How do you define vexatiousness?
I'm going to ask Mr. Lamy to answer that question. Well, the concept of vexatious conduct isn't understood purely subjectively. We use the reasonable man rule, a reasonable person in similar circumstances. You might find yourself, for example, you could see vexatious conduct might change or be appreciated differently from one situation to another, but you would use the reasonable person rule, and this is also used in other places in Quebec civil law. And so it hasn't really posed a problem in applying this concept.
The reasonable people kind rule, but I wonder if any other witnesses have thoughts on how we define vexatiousness.
You can define it in the legislation. I mean, it's a generally understood legal concept with regards to what is vexatious and what isn't. I think it's the same. We've had no problems with regards to dealing with that in Ontario. And same as my friend has mentioned with regards to Quebec, it's generally understood. And so using that word just generally isn't a stumbling block. Okay.
Thank you. I wanted to follow up on some of the discussion about Canada Post and some of the connections made to some of the previous testimony on that, because this, to me, gets to the heart of some of this question of what constitutes the definition of harassment. We had a gentleman speaking previously about how, in his view, the response by Canada Post to, I think the phrase he used was innocent absenteeism or something like that, how that the response to that constituted harassment. And I guess I would be curious to know how Canada Post responds to innocent absenteeism, because it seems to me as an employer with a parliamentary office here that you need to have some kind of a response to absenteeism, innocent or otherwise. Does it create problems for an employer when that is qualified in some quarters as a form of harassment when people are, depending on what the response is?
So a couple of things. When people are absent from work, I think we as an organization, we as an employer, want to see them be well, right? So following up and making sure people have the right support is absolutely important, and I think that's the principle that we keep in mind. Do we talk to people and make sure that they're getting the support through their physician or otherwise? Yes. We have, at Canada Post, we have a pretty extensive disability management team. They're professionals, and their job is actually to ensure that the right medical processes are being followed and the right support is provided. And so with respect to absenteeism, again, we have a desire to make sure that people do get the right attention and so that they're back at work where it's probably a healthy place to be. So maybe Manon has experience in this. She can add to that. Or
I think you said it all, but all I'm going to say is as a leader in operations, I always encourage team leaders to be good human beings and to welcome their employees back to work. They know their employees the best. Welcome them back to work, ask them if they're okay, and provide the support systems that Anne-Thérèse talked about if they're not. So I think that's just being a good leader. So I certainly don't see that as harassment in the definition that we know.
Yeah, and I'll ask a follow-up question, then maybe open it up. I mean, is there a risk that we get into a situation where, yes, of course, employers want to do everything they can, generally speaking, to help their employees be well and be able to come to work, but is there a risk that you have a situation where an employee is basically not doing their job in the proper way and seeks to use a harassment process or a complaint of harassment as a way of basically countering their employer's efforts? Ms. Johnson shaking her head. So please tell me how we avoid that potential risk.
See, it's hard to avoid because it is something that happens all the time. And so that's why there's the exemption that should be in there with regards to good faith allegations that are being made, and the exemption with regards to anything that's done by management as part of its proper management rights and doing its proper progressive discipline wouldn't be considered to be harassment. You can't avoid the possibility that someone may make a complaint that they're being harassed, but that's why you investigate. And that's why you decide what's the appropriate manner of investigating. It may well be looking into the history and finding out that it's the case, that it really isn't a case of harassment, and have it done there without having to bring in a third-party investigator in order to deal with the situation.
I wonder if it raises some concerns in the parliamentary context, and Ms. Johnson, if you have thoughts on this, in which basically it's the Minister of Labour's office that is involved in making those investigations, which could involve investigations into the offices of opposition MPs. It could theoretically involve her having to do an investigation into her own parliamentary office as well. Does that seem
wouldn't
like
be appropriate?
Right.
And so in those contexts, there should be flexibility built in that it should be an investigation done as appropriate in the circumstances. I think that language should be in there in order to give it some flexibility with regards to what do you do in the circumstances. And so in that context, it should be someone who is independent and trained to do those kinds of investigation, who's completely neutral and impartial with regards to the process.
Thank you.
You're welcome.
Now over to MP Fraser for 6 minutes, please.
Excellent. Thank you very much. Over the course of the testimony, I think we're narrowing the number of issues that there seems to be different perspectives on. I sense that most people are pretty happy that this issue is being tackled, but it comes down to the details. One of the areas where I think the details are still controversial to a limited degree is really on how we ensure there's integrity of the process, specifically on the issue of the role of the committees versus sort of a more employer-driven process. Mr. Hines, I think you said we shouldn't automatically default to an external third-party investigation. I'm curious, just a few questions on this issue. And perhaps Mr. Hines, since I think it was your comment, why would the employer be the better first stop?
When we first started talking about the issue of sexual harassment in the federal sector in a tripartite way, and we were considering what the alternative ways forward were, one of the options that was presented by the government was to take this clause in Part 3 of the Canada Labour Code and move it into Part 2 for a number of reasons, one of which it would broaden the scope of who that clause now applied to. One of the issues that percolated during that initial discussion was, well, who should be involved in these investigations? And there was, I believe, a general recognition and acceptance at that table that sexual harassment complaints, sexual violence complaints were different. There was a sensitivity around them that made them different than a typical violence complaint. And I think what was generally agreed at that table was the number of people with access to that information throughout an investigation should be really tight as you can possibly make it. So that really, I think, was the genesis of removing the Workplace Committee from the investigatory process. That did not mean the Workplace Committee could not be involved in setting the policy, ensuring the policy is enforced properly, dealing with any systemic issues of harassment in the workplace. What it meant was, in individual investigations, there would not be a specific role for the committee. That doesn't mean there wouldn't be a role for the union. The employee could go to their union rep to seek assistance and seek guidance, to file a grievance, to go through the process. So that's kind of where that came from. I don't know if that answers your question.
It's very helpful. I'll want to just ask Ms. Johnson a similar question. I note that the testimony in response to my colleague Mr. Genuis's questions to the folks in the airline industry, who I think are still in the room here now, essentially said, look, this is a really serious issue for us. And I understand why it is. You don't want the investigator to be the harasser. It makes no sense.
No.
But you, Ms. Johnson, suggested that there's a process that I think you would have faith in, as long as there's a government backstop to ensure the investigation was done in a reasonable way. Can you explain why that's the appropriate safeguard that both protects the privacy of everyone involved, but also maintains integrity in the process?
I think what I was saying with regards to that is I agree that there should be flexibility initially with regards to the workplace parties themselves being the ones to address the issue and to investigate it and to try to resolve it. And I think that is what's being reflected in the bill as it's currently drafted. And with regards to what my friend said about, there being that privacy that needs to be done to keep the Health and Safety Committee out of it with regards to those kind of complaints is reflected in the bill, because there's the exceptions with regards to Section 128 and 129 when you're talking about the investigations. To me, having the parties own it is very important with regards to the integrity of the process and having them being committed to it. However, when they aren't doing what they are supposed to do, and if the union's concerned or an individual employee is concerned that the employer has only gone through the motion with regards to the investigation, or the employer has had a inappropriate result, then you go to an independent third party as the safety valve where the internal process hasn't worked.
So building on that, I want to create a system here where we encourage people who've been harassed to come forward.
Mm-hmm.
If the option feels like you're going to somebody where justice won't be given, I would understand why there'd be a chilling effect and somebody may choose not to report. You mentioned the idea of ensuring that there's someone in a separate chain of command. I think it was our witnesses from Canada Post suggested that they have an ombudsperson type model for this kind of scenario. Does the legislation need to be changed to accomplish this? And if so, how so?
It does, because the language as it's currently drafted says report to your supervisor. The employee reports to their supervisor. That's too closed. You need to expand that, and you need to have it be the employer supervisor, and then perhaps have a section, like a subsection saying, and when the person involved in the allegations is the employer or the supervisor than a neutral third party. And you can leave it flexible as to who that is, but for the employer and the workplace parties to think about who would be the appropriate person that people would feel comfortable coming forward to without fear of reprisal.
Excellent. My final 30 seconds, different topic. Mr. Hines, you talked with the consultation today and referred briefly to the regulation versus legislation for the definition of harassment. One of the things that I do have some concerns with is the inability of this committee over the course of about 8 hours to properly consult all the stakeholders to make sure we've got the definition correct. Do you think this is a reason to get it right by putting it to regulations so stakeholders can be properly consulted both on the employer and union side?
Yes. I mean, I think that is the most appropriate place to have that conversation where the experts, the stakeholders can meet and go through what honestly is sometimes a painful process of, fighting over words, ands and ors and buts that matter at the end of the day. But what we end up with, I believe, is a solution that is mutually agreed to, where we have language that is then embedded in regulations that literally has the force of law, that I believe accomplish a better result than if, to your point, we do that, in the next few hours.
Thank you very much. And for 5 minutes, MP Harder, please.
Thank you very much, Chair. My first question here is going to go to Ms. Johnson. You've made some excellent comments and observations with regards to the power of investigative work and where that's concentrated, I suppose you could say. Just wondering, once a report has been composed, an investigation has been completed, there's now a report. Right now, the legislation doesn't say that report needs to make its way back to the complainant. Do you believe that would be a good addition to this piece of legislation, or do we just leave the complainant out of it?
No, I don't think the report itself, especially if it's with regards to a sexual harassment situation, because you do as much as you possibly can as an investigator to make sure that the witnesses aren't identifiable either. And so having the whole entire report be exposed to a certain extent undermines the commitment to confidentiality and other concerns that you may have with regards to the process. I think the result, as well as the implementation with regards to what happens as a result of the result, should be something that goes to both the complainant as well as the respondent. But I don't think the report itself should be provided.
Okay, thank you. My next question for you is along the lines of a competent person. So a competent person can be put in place in order to help the process, help work through the process, the investigative process. Now, right now, there is no definition in terms of what would qualify a person as being competent. Do you believe that is something that should be added to this legislation?
I think it falls along the same line as what we're discussing with regards to some of the other definitions. That might be better to put in one of the regulations, or because competent, it should be someone who's had training, who's done it before. It should be, someone, actually in Ontario, they have some of it built into the legislation. As an example, if it's going to be a private investigator, it has to be a licensed one, a lawyer. But those things are given as examples, not as, it says a competent person, and they give examples such as a licensed private investigator, but they don't specifically say it has to be this, or this. And I think you limit yourself too much if you put in a very specific definition in the code itself or like the bill to the code with that.
So would you even caution against a general definition?
A general definition I think is a very good idea. I never caution against the general one. It's the specific saying it's limited to these set people would be problematic.
Okay, thank you. My next question then is going to go to Mr. Hines. Now, in this piece of legislation, it's interesting because one of the things that it does is it actually allows for the department to conduct pilot projects in order to test the effectiveness of new rules or new regulations. And so it says in the legislation, in the legislative review, that the purpose of a pilot program is to test new rules in a specific industry or region. And so given that the federal government regulates businesses that operate across provincial borders, my question for you is, wouldn't this create competitive disadvantage for one region or one industry over another?
I don't think necessarily. I think where that clause is trying to get at is examples where the department is trying to learn ways of doing its work better. So it wants to launch a pilot project around the way it for example, ensures compliance under the Act or under the associated regulations. So unless that pilot project involves some onerous responsibility of reporting on the employer community, there might be a way of managing it in a way that has not much of an impact, but I think we'd have to negotiate that certainly with the department as we move forward.
So, for example, like let's say new regulations are put in place with regards to fishing boats in Nova Scotia, but those same regulations are not in place with regards to fishing boats in New Brunswick. Would that not put Nova Scotia at a disadvantage, quite significantly actually, because of the incurred cost that it would require to meet those regulations in that area?
To that example, I guess you're correct that it would impose a burden in that particular place, yes.
So speaking on behalf of stakeholders, with industry stakeholders, would you support that?
What I would say is I think that the intention behind this clause is not to do as you've described. I think the intention is to ensure that the department is doing its best to ensure compliance. So they may look at specific industries in the way that it's doing its work and review its work in that regard. I don't think it's necessarily to create standards that exist only in one region against the other.
Ms. Johnson, do you care to comment?
If it's done as the industry as a whole, I think that's fair. Doing it by region, I think, could lead to those issues that you raised.
Thank you. MP Trudeau.
Ma question est peut-être pour Madame.
My question is for Ms. Johnson. With Bill C-65, what do you think about small workplaces where there are no unions, where people would people have to lodge a complaint with their employer? What if the harasser is the employer? How would the bill apply? How should it apply? I'd like to know what you think.
Less resources and less anonymity almost, where the employee is going to feel much more exposed. And so they're probably going to feel much more intimidated in coming forward. I think myself, with regards to my experience, is it shouldn't matter the size of the organization with regards to what their obligations are in the workplace. However, perhaps with regards to some of the plans, like in Ontario, what they do is anything under 5, like if there's 6 or more employers, it's every obligation. Under 5 employees, then it's the case, and it's 6 employees. But under 5 employees, then you don't have to post everything, and you don't have to do some of the other things that are required as a bare minimum because you're so small. But I think the general obligations as a duty of an employer with regards to ensuring the health and safety in their workplace should apply no matter the size of the organization. The difficulty is going to be having another person that they can report to, but it doesn't necessarily have to be someone internal to the organization. In Ontario, you are allowed as well to have someone outside of the organization be that safety valve. And that's something that could be considered with regards to the small workplaces.
Donc, pensez-vous que dans la réglementation...
So do you think that in regulations it's something we should add for employers of small businesses? Do you think that we should have something in there dealing with external facilities or persons?
Regulations would be helpful. I'm always cognizant of over micromanaging situations as well and making it difficult for employers to function. However, depending on how it's done, I do think that requiring them to have, if they're not going to do it on their own and it becomes a problem for sure, or it is demonstrated to be a problem, then it should be a requirement built in that there be an external.
Thank you. So that ends the second round. We have about half an hour remaining of our time, so we have enough time, I think, to do a third round. And up first, we would have MP Genis, please.
Thank you, Mr. Chair. How much time?
6 minutes. Use as much as of it as you wish.
Okay. All right. Well, maybe one of my colleagues will jump in. We'll see. But let me start with this question, just in terms of the general environment around this legislation. It seems to me that having new rules, potentially stronger rules, arguably maybe weaker in some respects, but in any event, new rules, doesn't change the fact that some of these questions will be discussed and partially adjudicated in the public, in the media. So what happens when somebody either A, doesn't use the designated process, even a new process, and instead allegations are made against a company, maybe represented here, maybe not, in public, or let's say an investigation is undertaken and a determination is made that harassment did not occur, or maybe the complainant isn't satisfied with by the remedies, and then there's further public comment around that. How should companies respond to these kinds of public discussions? How should we all respond to them? Because it seems that these is a legitimate concern when people hear these kinds of stories, and they don't necessarily see other aspects of the process that may or may not have occurred.
With regards to what we can regulate how people treat each other inside of the workplace. But with regards to people going out and making public statements and dealing with publicly, we can't regulate that. But I think we as a society and we as people reacting to it need to remember we live in a democracy, and we have to remember there's due process, and we have to remember, always, as in any context, always, ask questions, accept what's being said in good faith, however, ask the questions, follow up, look underneath, and make sure you're fully informed of what's happening before you make a comment or make a decision.
Does anybody else want to comment on that? Okay. If not, then I wanted to probe further this issue of whether or not harassment should be defined in the legislation or in terms of regulation. I think we've heard some perspectives from both sides. Maybe Mr. Hines, I know you'd suggested regulation, so maybe I'll just make a quick comment from my own perspective and then give you a chance to respond to that. I guess it seems to me that given some of these fine distinctions that we're talking about and potential slipperiness in certain cases about what is covered by a term and what isn't, it is important that we have a clear definition and one that's well known and one that has broad buy-in. And it would seem to me that it's the function of legislation to establish the framework, but also to deal with the most important aspects of legislation and leave the details to regulation. But to ask us as legislators to pass a bill that creates a specific process for dealing with something called harassment, but doesn't actually say what that something is a little bit of an unusual way of legislating, saying we're gonna have a process for dealing with thing X, and we'll leave it to the government to, in the future, define exactly what thing X is and revise that definition in the future. And I suppose leaving it to regulation requires us to trust the good faith of government and to assume that they have the noblest of intentions in providing that definition, and very often I'm sure they do. But our function as a legislature is to hold the government accountable, to establish clear parameters when we legislate, not simply to say, okay, here, go ahead and define this thing that we think is very bad but have yet to define. Mr. Hines, what do you think of those arguments? Do they hold water in your view?
I think leaving the details to the regulations is the legitimate way of approaching an exercise like this. In the case of occupational health and safety in the workplace, we have the Canadian Occupational Health and Safety Regulations. I mean, that document is maybe 250 pages long, and it has provisions in it that set the framework for what are the occupational health and safety requirements in the workplace. And employers are held to that standard, and compliance is enforced by the government. So in the case, for example, of violence in the workplace, the definition of violence, as I understand it, is embedded in the regulations. So the argument that we've made is the same should occur here. Not necessarily we negotiate, but we bring together the experts, those around the table with on-the-ground experience of what this looks like, the legal community, the business community, the labor movement, government officials, and others, and we work through the details of what that definition looks like. I think this bill and the changes that it will bring to the Canada Labour Code does create a strengthened, a strong umbrella framework for addressing harassment and violence in the workplace. It moves the chains along further from where it was previously. But in terms of those specific details around the definition, I fundamentally think it just makes the most sense.
Thanks. I want to get Ms. Johnson in, but I guess for me, honestly, that doesn't address my issue. That yes, there's obviously a working out process that has to happen, but legislators are being asked to pronounce on a process for dealing with something before that working out process has happened. Whereas generally what you expect with legislation is that working out process happens. Yes, it happens in places like here in the Parliamentary Committee, but then we ultimately have the ability in a third reading vote to pronounce on that, right? Ms. Johnson, your comments on this.
I believe that, and I could come up with one right now, what the definition of harassment or violence would be. And I think you need that general one that everybody understands built into the legislation, that it's either common or, like violence, for example, common or conduct that could result in physical or psychological harm to an employee, whether it's threatened or actual, right? Like the employee has to believe they're going to be harmed. And that is something that I think is very broad, that can be applied to many, many circumstances, and then you have the regulations to flesh it out. But I do believe a broad definition should be in the legislation itself, with the fleshing out done in the regulations.
Thank you very much. And now over to MP Morrissey for 6 minutes.
Thank you, Chair. I just want to follow briefly on the last discussion. Mr. Hines, you have witnessed numerous legislation. So is it unique for a piece of legislation such as this to put an item that would require a lot of examination when you're defining harassment, because it is so within regulation versus legislation?
No, it's not unique. Frankly, I think it's the way that the process works. On the regulatory side, when it comes to occupational health and safety in the workplace, we meet in a tripartite way regularly. There is a go-forward regulatory plan that the department publishes when it looks at regs that they feel need to be updated because circumstances have changed, our understanding of issues have changed, technology has changed. So what we do then is we open those regulations and we go through them in a tripartite way and discuss ways of revising them. We just finished one a number of months ago on the issue of confined spaces in the workplace. This is, I believe, just a fundamental part of the process, that the legislation lays sort of the overarching framework for the way forward, and then we work out the details through the regulatory process, which can be time-consuming, but is fruitful because I think we end up with a result that all the stakeholders around the table and society at large can agree is a logical way forward.
Could you do both? Because Ms. Johnson made a reference to maybe a general definition and then a more detailed definition. Would you think that would be a conflicting process?
I'm not sure it would be conflicting. I think what we would have to do at that stage is have a discussion around what the language in that overarching definition was. And I believe, as parliamentarians, you might want to hear from the stakeholder community around the specific language that's embedded. It could work. I don't know if it's normally the way we would do it federally, but it could work. But I do think there should be certainly a fulsome conversation at the front end around what the specific language would be.
Okay. I have two very different questions. One is to Ms. Johnson. I believe it was you that made the reference, and this has not been discussed a lot, is to mitigate against being found guilty without due process. Nobody likes to talk about it much.
I think that's a very important part of the process because you're going to get a lot of strong reaction one way or the other from the employees in your workplace as well. When anyone comes forward, they're generally, in my experience, there are always going to be camps of employees with regards to the complainant versus the respondent. And in order for the entire process to be respected, it needs to be respected and encouraged in a manner with regards to, we need to respect confidentiality and the dignity of everybody involved. And that includes no gossiping, no talking about it, no coming and judging to decisions, that we need to go through our process. We need to, apply natural justice. We live in a democracy. We have a criminal justice system that you're innocent until proven guilty. And I think that is something that everybody, the stakeholders, the employers, employees, all need to grasp and hold on to with regards to ensuring that this is all done right. Because if we go too far to one extreme or the other, we undermine the entire process.
Do you think the legislation is strong enough in that area?
I think there is some definite language that you can add to make it stronger with regards to, I didn't see anything in there with regards to like minimums. There's no reprisals if you come forward with a good faith allegation, as I mentioned earlier, or that you participate as a witness, as long as you do so in good faith and you're not vexatious about the complaint. With regard, there's exceptions that can be put in, as mentioned earlier, with regards to the proper exercise of management right doesn't constitute harassment and or violence in the workplace. And so there are definitely gaps that are in there that could be filled.
I want to go back to Canada Post, because there was real conflicting testimony given earlier versus today. And in fact, this is not a direct quote, but it's close. When a witness said this systemic harassment in Canada Post managing overtime on routes, bonuses to supervisors is determined by managing overtime. Would you care to comment on that? Because the testimony you were given now is that this does not happen.
So if you think about creating a positive workplace culture, we talked earlier about the importance of leadership. And there's probably no more important role than a team leader with his team. So it's counterintuitive for an organization, including ours, to incent people to...
Can I stop you there?
Sure.
Because I want you to comment specifically on how Canada Post manages postal workers, especially postal route delivers, on going excessive overtime to get what Canada Post determines the timeline that it should take to complete a route.
Very, very briefly, please.
I'm going to turn this over to my colleague who's...
So we have thousands and thousands of routes delivering parcels, mail to Canadians every day. And like any other business, there's overtime required on certain days. And there's a process for employees to have an interaction with their supervisor. They know their route the best. So we ask them before they leave, you've seen the mail that you have, come and talk to us about what you think you will have in overtime. And there's a process after they're done for the day where they need to come in and talk to us about their overtime as well. So that's the interaction. It happens thousands of times every day in our operation. When there's what's considered above average overtime, there's, it stands out. And of course, as a responsible employer, we need to have a look. We need to understand why an employee would work 4 hours a day, every day, on a route that's built on averages. So there's a process to handle that. And that's how we manage overtime at Canada Post. It's a daily occurrence.
We're actually over time, so.
Oh, sorry.
MP Trudel, please.
Merci. Ma première question va être...
Thank you. My first question is for Mr. Dorval, and then for Mr. Heinz and Ms. Mondal. Well, we heard from officials in committee who appeared on February 12th, and they mentioned that there are courses that would be linked to the implementation of the legislation. So it was also mentioned that in the long term, that there's been absenteeism, a drop in productivity, and also a drop in contentious issues. I'd like to know what you think about the costs involved and about what this might mean for small employers in terms of costs. It's Mr. Dorval speaking. Well, now, in the regulations, and we said in our brief that it's important that there be regulations at the same time as the legislation is enacted. The costs associated, you have to remember that employers have an obligation to maintain a healthy and safe workplace. So they have requirements that would lead to vigilance, to the processes necessary to maintain health and safety, for example. So it doesn't mean completely changing the situation for employers. Now, if a regulation set forth very detailed processes, and I'm going to get back to the small businesses here, would these require small businesses to have recourse to external expertise in order to deal with policies, or would they have to have recourse to certain external mechanisms that would cost them? There would be costs involved. And this might be one of the inherent responsibilities of an employer. There are already costs associated with being an employer. Now, there was a question put earlier, and according to us, in all these situations, the requirements are really there already. It's not as if we were going to be revolutionizing what's already there. And we shouldn't think that we're in such a different area, because in the workplace, if we look at occupational health and safety, it is a legal requirement. So what I would say to you is that there will be costs. These costs will depend more on the magnitude of the legislation and its requirements. They already talk about responsibility. But there are many responsibilities assumed by employers already. Ms. Mondal or Mr. Hines, do you have anything to add?
With the banking industry, as I mentioned or set out in my opening remarks, a lot of the measures required by the bill and the regulations are already in place. So lucky that way, but to echo what Mr. Dorval just said, that was in a sense always the obligation, and banks took some proactive steps to have policies and processes and all the things I mentioned earlier. In terms of costs, I mean, there's of course always going to be costs of compliance with new rules, whether that's on the reporting side, whether it's audit functions, whatever is put in place to meet the letter and the spirit of the law. There will be additional costs, which might be more burdensome for our smaller banks that do have less resources than the largest. And so the suggestion I would have there is two things. To the extent that the regulations can be streamlined and made clear, so not a lot of money is spent on lawyers on how to interpret them. I'm a lawyer, so I can say that. And the second is flexibility. So for those employers that do have practices and policies in place, if they could leverage off that, and if there could be some recognition that, the way you do this, the way you meet the objective of Bill C-65 doesn't have to be exactly prescribed either in the legislation or the regulation, but managed and understood by the labor program and others in a way that we don't have to replicate what we're doing.
I can't add much to what Ms. Mandel said. I wholeheartedly agree with every point that she just made. The large employers that I represent in FETCO generally already align with the new provisions that we put in place. Will there be some incremental costs around new regulatory requirements and reporting? Expect to be so, as there is when any new legislation or regulation is introduced. I mean, at the outset, as we've been articulating, the harassment-free workplace that's the ultimate goal that any employer wants to see. I mean, not only is it just simply the right thing to do, it's good for business. Absenteeism goes down, productivity goes up, your employees are happier. It's all good for everyone, which is why we are supportive of this bill. Will there be some incremental cost increases? Likely. But as we stated earlier, as Marina did, we generally align with the principles that are laid out in the bill and the process been articulated anyway, so don't expect a tremendous change.
Thank you. MP Fraser, please.
Perfect. Thank you very much. I want to just shine a light a little bit on the competent persons selection process. There was some testimony, I can't recall who made the point that perhaps the appropriate method of selecting them would be to say, look, give us some clear guidelines, but potentially default to the employer's choice. I keep coming back in my mind, trying to put myself in the shoes of a harassed person in the workplace who's not at my best because I've been harassed and I have no faith in the process. The natural human reaction is not to go to the legislation, the provisions in the regulation and say, oh, I have faith the employer put a good person there. They would tend to, I think, if I can read human emotion well, is that they would say, I don't want to go before the selection of the person or company that has perpetrated the harassment. Is there a role for the unions and the employees to have a voice in who the competent people are who are going to be conducting this investigation? And I'll open it up to whoever wants to jump in. So, Mr. Hines, go ahead.
Yeah. So currently in the health and safety regulations under the violence investigation process, there are criteria that are laid out for who the competent person is. And they are as follows. The competent person is to be defined as somebody who is impartial and is seen by the parties to be impartial, has knowledge, training, and experience in issues relating to workplace violence. In this case, of course, it would be harassment, and has knowledge of relevant legislation. The issue that we sometimes come up against, and normally that works fine, a competent person is appointed in large organizations. That is often a person within the organization who has met these criteria and is agreed to by parties to be reflective of those criteria and could therefore conduct an investigation. In issues where the complaint is more egregious or more sensitive, you might bring in an outside investigator to conduct an investigation on your behalf. One of the issues that we do see come up from time to time is some complexity around choosing the competent person and a debate, if you will, between the employee or the union and the employer around who that person should be. One side might agree that the criteria are met, the other side might not, and therefore what is implied is some sort of a veto right over who the competent person is. We think that this is an important matter that we should work out through the regulatory process, that there could be a consultation around this and figure out a way forward. You know, I know some organizations have a roster, for example, an agreed-to roster where the union and the employer sit down and agree to a list of names, and we all agree they're all acceptable. So we think there might be a way of getting through some of those complexities.
I'm a bit limited on time. I'm just curious, other witnesses, very quickly, would there be a problem with having, for example, a roster in the arbitration context? This happens all the time. A roster of qualified people that ahead of time both the unions and employers have agreed to? I see some nods, and
so
give a chance to the witness from Antigonish. Go ahead.
Certainly that's our practice at Canada Post, and we're a large employer, so we have the ability to do that, but that's our practice. We publish it as well on our website. And the other thing we do, which I think is important to keep in mind, is agree to the person prior to an investigation taking place as well. And I say that because although I may be competent, perhaps if I'm too close to the matter, you know, you might want to have a different person. So what we do is agree prior to an investigation, okay, are we still going to assign this person or someone from a different part of the country or a different part of the city? So that's worked well for us.
Sorry, Ms. Maynard, were you trying to jump in there? Okay, I've got one more topic. Maybe we can revisit it if we've got a minute left. We've got a little bit of time. Ms. Johnson, you talked about there being a need to explicitly prohibit reprisals. Of course, I think fear of reprisals puts a chill on anybody who would consider reporting. I've heard of many examples of employers at our constituency office where people didn't know what to do, sometimes with federally regulated employers, where they can't point to a specific example where they were being bullied because they launched a complaint, but they haven't been promoted in 8 years and all their contemporaries have been, and there's this sort of soft, informal feeling of reprisal, and they could never prove it because it hasn't been proactive discrimination following the harassment complaint.
Direct, yeah.
That's right. So are there safeguards we can put in place to not just put on paper, look, reprisals are bad, you shouldn't do it, but actually to prevent reprisals from happening in the workplace, and how would we go about doing that?
That comes down to how you enforce the legislation. I don't know if you can specifically like regulate that or legislate that. I mean, you have your set rules, and you know, if they're not followed, then you know, what's the process for dealing with it? What I was mentioning earlier with regards to make sure you have the bare minimums in there with regards, so employees know, okay, I can make a complaint, this is the process, these are my protections under the process, right? That was the one thing I was talking about. But with regards to that scenario, there's no way of directly that I can think of legislating that.
So essentially, if you prohibited reprisals and an employee feels they're suffering reprisals, they could sue the employer, for example.
They could sue the employer, or you could build in as an enforcement mechanism that they have the ability to make a complaint to the government with regards to that, and then they can have an independent investigator look, like an officer or investigator, look into it and see whether or not there was a violation of the legislation.
Thank you. I think that's my time.
Pretty close. Pretty close. That is the end of the third round. Don't really have time to get into a fourth, but I am going to take this opportunity that we have just 2 minutes here to ask a question, something that I've not heard addressed today. I know that those that find themselves the victim of harassment and choose to avail themselves of whatever processes and opportunities are in front of them, one of the biggest concerns is the time that it takes to either address the complaint and then, of course, to resolve the complaint. Are there benchmarks within each of your organizations right now that you try to achieve? What are those benchmarks, and do you measure that in any way, shape, or form? We'll maybe start with Canada Post.
Sure. So we don't have a benchmark, and the reason we don't have a benchmark is situations vary so much. So depending on the details of the situation, it would be very difficult to establish a benchmark. What I would say is two things. Timeliness is really, really important. So being able to not only begin an investigation, but close an investigation as quickly as possible, and of course as effectively as possible, is important. And it also reflects on the whole notion of how do you prevent these from recurring, right? So if you're able to address things effectively and quickly, it'll help the recurrence of an incident. So that's our position.
And the banks?
So there are no benchmarks, no set time limits for within which complaint has to be fully investigated and resolved, for reasons similar to what was just mentioned. So what I can say, there's commitment from the banks to the complainant to have a timely, thorough, confidential investigation. But when you think about the range of inappropriate conduct to sexual violence, the range of things that could be alleged, that could be brought forward, to have a timeline like 6 months, 12 months, whatever that is, doesn't make sense. The commitment really is, this is some of the most sensitive things we could be dealing with in the workplace, and we don't want to manage to deadline. That's not going to guarantee the most optimal outcome and the most optimal resolution. And the added factor to timelines is there's certain complexities that is fully outside the control of the employer. If one of the parties is on a leave of absence, cannot be interviewed. If there's IT issues, like an email poll that takes X amount of weeks or days. If there's other experts involved, medical or legal. So yeah.
I'm almost out of time here, but I want to jump in here because I'm thinking, I understand the idea and the concern around benchmarks, but the other part of the question, is it measured? I always conduct, in my past employment, if it wasn't measured, it's not done. And my concern is that it's not something that I'm hearing in many industries, that it's being measured at all. And we hear time and time again from victims that the time it takes to go through this process re-victimizes, adds mental, like it becomes mental health due to stress issues and all these things. So it's just, we're out of time, but I just want to leave that thought with you that regardless of whether it's in the legislation or not, we really need to get to a point where we're communicating, at least communicating to the victim what that timeline is going to look like. So anyway,
thank you.
I have to close it at that. I want to thank all of you for being here. All of you that stuck around from the earlier session. Again, a thank you to you as well. Thank you to my colleagues. Thank you to everybody that makes these meetings possible. People to my left, to my right, and behind me. And enjoy the rest of your week, and we will see everybody back here next week. Thank you very much. Adjourned.
Thank you.